I'm having too much fun with these images. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything. It ends with us, saga. And this video is a 2-in-1. Starting off with something in motion, literally and figuratively. Remember last week when Betty Snooze filed a 2-page response to Jed Wallace's motion to be removed from her lawsuit? Not by choice. Her legal team would have written pages and pages, but the judge ordered them to have their response be 2 pages max. They filed that and insisted that the social media expert hired by Justin Baldoni last year was a relevant party to this case and that he knew what was going on. Blah, blah. Not so fast, says Jed Wallace. He just filed a new letter with the court, and I told you this morning it was going to be a busy day, and I was right. Everybody's come making it rain after the holiday. And poor Jed Wallace already took an L. Remember that? I made a video prior to this today. Watch that to be fully caught up. The judge ruled that if deposition has to happen, if he is still a part of this, because the judge hasn't ruled yet on his motion to dismiss, the judge said that Wallace's clients are not protected. Their identities, that is. Wallace had been arguing that the client names were not relevant, but Team Pinocchio said, yes, they were. And the judge agreed with them. However, it is possible that before today and the date that Jed Wallace is supposed to be deposed, Judge Lyman might rule that he doesn't have to be attached to this complaint anymore. Which would make sense, I think. Wallace has smartly and correctly argued that he was the first to file, so litigation should happen where he filed it in Texas. And also, he argued that she has no jurisdiction over him in New York. But last week she explained why she does, flimsily. And now it's Jed Wallace's turn again to tell the judge in this last hurrah before the judge decides on Wallace's motion to dismiss why he should be dismissed. And smartly, Wallace's lawyer keeps it to 2 pages as well, even though they were not ordered to do that by the judge. The legal standard, they write, a proponent must allege that the defendant was part of a conspiracy involving overt acts in New York, in which defendants joined and participated. A proponent must further establish 3 additional requirements: awareness, benefit, and direction or control. They argue that Wallace, the sole employee of Street, denied that he participated in a conspiracy and testified that he had no knowledge of it. All but one of the New York acts Lively alleges occurred before early August 2024, when the defendants, according to Lively, joined the conspiracy. So far, making a lot of sense. Meaning also, before that point, Jed Wallace had not been hired. The other act concerns alleged press contacts by Nathan, but Lively does not indicate when her New York conspiracy acts, if any, occurred, and Wallace has testified that he always dealt with her in California, meaning Melissa Nathan, and she represented a California client. Boom, again, score for Wallace. Additionally, the New York meeting where Baldoni and Heath heard her complaints happened in January of 2024, like a full 7+ months before Jed Wallace was hired. There is no allegation that defendants knew about it. Ooh, this is an interesting one as well. Jones works an alleged co-conspirator contract. There is no pleading, amended complaint, or response to the motion to dismiss that alleges that Jones Works was a co-conspirator. Lively's letter last week alleges this for the first time. I pointed that out for you. That language was very interesting, calling Stephanie Jones's company a co-conspirator alongside Baldoni and company. Wallace says the implausibility of Jones Works acting as a conspirator is patent because of the Jones Works and Wayfarer litigation, as the court knows. We ask the courts to take notice of the Wayfarer Jones Works agreement in case number 125. Additionally, the contract that Lively references over 4 years ago is between Wayfarer, a California client in Los Angeles, not New York. Also, it seems that Melissa Nathan moved at some point from New York to Los Angeles, and Jed Wallace never knew her as working in New York. Steve Sorowitz's comments to bury her happened before Jed Wallace was hired. Jed Wallace had no knowledge of the New York contacts that she mentioned. Also, Jed Wallace did not direct or control any alleged conspiracy. And this is so smart. It would be implausible to think that a vendor, Street Relations, joining after the alleged aims of the conspiracy had largely, if not completely, been met on a 3-month contract could do so. Very well pled. Hopefully the judge will rule on all of that sooner than later. And Judge Lyman is about to rule on yet another, I think, important decision. As I previously reported, the garden variety actress took the unusual step of subpoenaing Justin Baldoni's attorney, Brian Friedman, who is also my attorney, but will not be handling the subpoena situation that I'm seemingly involved in. Understandably, Brian Friedman and his law firm did not take kindly to that, did not think that was appropriate, so they filed a motion to, I have something in my teeth. Oh well, I'm not redoing this video. Brian Friedman and his law firm filed a motion to quash the subpoena in a Los Angeles court where the subpoena was served. This all went down last month. Well, Blake Ruin Your Livelihood filed her own motion to transfer the subpoena and the motion to quash over to New York for Judge Lyman to decide. And the court in California has ruled in her favor. Why? The judge in Cali ruled, quote, "A third party subject to a subpoena may challenge the subpoena in the district where compliance is required," Los Angeles, and that happened. However, when the court where compliance is required did not issue the subpoena, it may transfer a motion under this rule to the issuing court if the person subject to the subpoena consents or if the court finds exceptional circumstances. And that's what's happened here. The court found exceptional circumstances. The Los Angeles judge says the court has considered the factors outlined above related to the underlying litigation and concludes that respondent has met her burden to show that exceptional circumstances justify transfer of the motion to squash to the Southern District of New York. As an initial matter, the New York actions from which the subpoena at issue arises date back to December 31st, 2024, and have been heavily litigated over the past 6 months. The current fact discovery cutoff in the lead action is August 14th, unless the judge extends it as they want, and the parties were required to achieve substantial completion of document production by July 1st. The presiding judge has ruled on a wide variety of discovery motions, including subpoenas to third parties. These prior discovery rulings by the issuing court create an exceptionally high risk that any ruling by this court on the issues raised in the motion to quash would interfere with the presiding judge's management of the New York actions. So she wins, for now. Thoughts? Let's discuss in the comments section.